Some of the 5500 forms are pretty archaic, and it's only a lawyer like yourself who can really understand them. Where do you think advisors should go to get help in their due diligence when they're looking at these forms?
It's really necessary to educate yourself. Again, remembering that the standard to which an advisor is held under the law is that of a prudent financial expert familiar with industry practices. So you have to dig in many cases. You may have to advise the sponsor that they should be furnishing more information on their 5500. You may have to ask the sponsor for additional documentation of things such as expenses and investment options. And in addition to doing those things, if you don't dig into it, then you're advising with blinders on, which you don't want to do. Now that we've got fee disclosure requirements from the DOL, much more enhanced than before, it should be very possible for the sponsor to break those fees down, and they should be doing that anyway. So if they're not filling out the 5500 form correctly, the plan advisor should be in a position to tell them how they should change.
Let's talk about some of the specific cases that you've been involved in. Boeing, for instance, $57 million settlement. It's a lot of money, but in the greater market cap scheme of Boeing, it's not. Do you think real change is going to come about as a result of the settlement?
Absolutely. In fact, we insisted in that and other settlements, even after money was agreed on, that we would not settle the case unless there were reforms to the plan to change things going forward and benefit participants. And in fact, in the Boeing plan and in other plans, the value of those changes in the plan going forward is greater than the amount of the actual settlement in dollars. In Boeing, for example, during the course of the litigation, Boeing did things moving its massive, and it is massive, $46 billion, second biggest in the United States, moved it from mutual funds to separately managed accounts, which, as most people know, can be obtained for far lower rates. They hadn't had record-keeping bids for 10 years. During the course of the litigation, we said they should have had them, and they did that while the case was pending for over 9 years. So changes came about that have value greater than that $57 million to the participants, and that's a good thing for the workers and retirees in not only Boeing, but in many other plans.
You recently brought an excessive fee case against Anthem, which doesn't target, but references Vanguard. Are you crazy to bring an excessive fee case that involves Vanguard? What's your reasoning behind this?
I understand that question, John. Vanguard, without doubt, is a very low-cost mutual fund family. However, Vanguard offers various share classes with various levels of fees. And in that case, in the Anthem case, Anthem had readily available lower-priced Vanguard funds, same manager, same asset allocation, same stocks, same investments, same everything except for fees. Identical investments for lower fees. It's no different than if you go to the grocery store and you have a sign on the shelf that says, if you buy 3 of these, you get the lower price, or if you have enough money to buy more, you get the lower price, but if you don't, you have to pay a higher price. If you have the money, or you're buying 3 anyway, you don't pay the higher price. The principle of that is not that Vanguard has poor funds. The principle is, under all circumstances, the advisor should be telling the sponsor, if you've got identical options for lower fees, you absolutely pick those institutional rates. And one thing for an advisor to keep in mind, and this is on the DOL website, is that a 1% difference in fees makes a 28% difference in the assets that employee will have at the end of a 35-year work career. That's huge.